Again for another episode of HR Shouts and Whispers. Ito, nagiging blurred pa yung mukha ko, di ba? Episode number 59. And syempre, ang topic natin ngayon ay what lawyers wouldn't tell you unless you ask. Syempre, solid tong topic na to. My name is Ken Somera and syempre, ang main host natin, si Cristina Reclamado. Hi, Chris.
Yes, hi Ken. Good evening to you. Okay,
Yeah.
so it's a busy week, I guess. I think kasi it was like I think today there was like a PMAP conference. Okay, so anyway, what we have here, we actually called on this very special guest because a lot of people have been asking us a lot of legal questions. Okay, so we'll talk about that. Okay, contracts, retrenchment, redundancy, and whatever. Even siguro pagka may utang ang tao kung pwede mo pa singilin. Anyway, I'll introduce, our special guest, But also, I'll also tell you that we have the other moderators of HR Shouts, So we have Benjamin, Marco and Jen, they're here with Ken. So our special guest, Attorney Pol Sangalang. Hi, Attorney!
Hello!
Yun, oh. What's up?
Good
What's up?
evening.
Magandang gabi. Yeah. Again. Yeah. Exciting tong episode na to.
Okay. So, Attorney Paul, so we were talking offline. So we'll start first kasi kind of we're adapting to the constraints, or the new challenges of the new normal. And usually it starts with recruitment. So let's talk about employee contracts. Okay. What happens if walang employee contract ang nag-start na aplikante?
Okay. Ganito yan. No? We have, a lot of us have this misconception na dahil sa walang written and signed contract, walang contract. No? Under our civil code, we have the law on contracts. And under the law on contracts kasi, as a general rule, contracts can be written or even verbal, no? At meron nga mga contracts na implied contracts, meaning yung mag-shake hands lang kayo or magkindatan, considered na may kontrata kayo. Now, so, what about employment contracts? Kailangan bang written ang employment contracts? No, it is not required, no? So, there are, we can have verbal or unwritten employment contracts. No? So, pag sinabi ng isang tao, let's say, wala naman kaming kontrata, maybe what they're trying to say is, wala kaming written contract. Pero, merong employment contract. Verbal nga lang.
Yeah, because I remember dati hindi uso yan eh. Parang sinasabi lang sa akin, first day mo tomorrow. Actually, in one company, I lasted 11 years, pero I didn't have any employment contracts. So parang wala. Even there was like some point nga, I got promoted, wala pa akong pinirmahan na promotion. Parang ganon. But eventually, when pagpasok natin ng year 2005, 2006, because HR, madami nang naging vigilant na yung HR and a lot of enlightenment happened. Kakaroon na tayo ng documentation. So, ang natin is, so we have a job offer and then an employment contract. So, what happens now if, halimbawa, yung applicant hindi sumipot sa first day of work? So, yes, oo, kasi syempre madami siyang offers na mimili siya. So, hindi siya sumipot. Can he be sued for damages by the company?
Yes, oo, kasi kung meron ng perfected, no? Ang tawag dito is perfected contract, no? Pag may perfected contract na, may rights and obligations na yung parties doon. So kung nakalagay doon na dapat mag-report siya on a given day at hindi nag-report si employee, that's a breach of contract. No? Kahit sabihin niya, hindi pa naman ako nag-start eh. Breach of contract yun. As long as there is already a perfected contract. Kailan ba magkakaroon ng perfected contract? According to the civil code in the laws of contract, kailangan may mutual consent between the two contracting parties. So we're talking about the employer and the employee. Meron ba silang mutual consent? Second, meron ba silang object of the contract, which is rendering service. At saka, the third element is meron bang costs or yung tinatawag nating consideration. Napag-agrihan ba kung magkano ang sweldo? So if there's an agreement kung ano yung tatrabahuhin, let's say a job description, and there's a compensation package, and then there's a meeting of the minds, no, mutual consent of the parties, there's already a perfected contract. Pag dito mo pa ng isang partido, whether employer or employee, there's a violation. So theoretically pwedeng idemanda ng employer si employee because meron siyang violation. However, practically speaking, no, kahit sabihin mong yes, pwedeng idemanda si employee, ano bang steps para mag-file ng isang legal case? No? If you're the employer, you would have to hire a lawyer. Siyempre si Atty. Sangalang.
Oo. Hire tayo.
May appearance fee. Tapos wala namang kulong yan. Di mo naman pwedeng ipakulong si employee. Hindi mo naman pwedeng ipadampot at ipakulong si employee. So, it might be practical to just move on to the next hire, no? Yun nga lang, syempre namimihasa. Minsan kailangan sampulan para matuto ang mga ganyang employee.
Kasi ang daming ghosting ngayon na nangyayari, attorney. So I was just also curious kung pwede mag-file ng damages ang company. Kasi ang dami nga. Anyway.
Yes. May suggestion ako, no? May suggestion ako to make the filing of complaint worthwhile. Kung lagi ka nabibiktima ng ghosting ng mga employee hindi sumisipot, no? Lagyan mo dun sa dun sa kanilang pipirmahan na if hindi sila sumipot, they will be liable for liquidated damages. No? And then pag liable sila for liquidated damages, you can sue the employee sa small claims court, no? Yung small claims, you don't even need a lawyer to file a small claims, no? And then yun, para at least mabigyan ng leksyon si employee, fill in the blanks, and then papadala na siya ng court summons, no? And then pag hindi siya mag-appear sa court, tama yung address, default na, no? A decision will be rendered against the employee, pwede na siyang i-share it.
I see. So there's a way. How about our moderators here? Okay, do you have any follow-up questions? Nag-ghost ba kayo?
Actually, yes, Chris, no? May mga applicants on the first day, they don't go to report to work. Now, I have a question to Atty. Sangalang regarding this. So in case that the employee wasn't able to report on the first day, can we just issue an NTE to the employee following due process and then afterwards terminate the employment contract?
On what ground? On what ground natin ite-terminate?
Yes, breach of employment contract, Attorney Paul.
Okay.
Breach of employment contract, and at the same time, insubordination to the employee was not able to follow the due process or the order notice that was sent to the last known address of the employee.
Kasi ganito, no? Under the labor code kasi, employees, once they're already employees, they have security of tenure. And then, as we know, the labor code lists the valid grounds or yung tinatawag nating just causes and authorized causes for employment termination. Kasi nga, because of security of tenure, the grounds for valid termination has been limited. So, first of all, to be able to do this, we have to find a valid ground, no? A valid just cause or authorized cause. That's why I ask, ano ang reason natin for terminating the employee? Now, if it's, as you said, it is willful disobedience, no? Pwede yun, no? Willful disobedience of a lawful order by the employer. So, we have to lay down the foundation for the ground, no? Kasi hindi lahat ng disobedience ay willful, no? According to the Supreme Court, not every time that the employee fail to follow the instructions of the employer, merong willful disobedience, that is a valid ground for termination of employment. Pag sinabi mo kasing willful disobedience, talagang nananadya, no? Yung rebellious, no? Contemptuous disobedience na binigyan mo na ng memo, gawin mo to, tapos sabi ng employee, hindi ko gagawin yan, bahala ka sa buhay mo. So talagang rebel. Yun yung mga klaseng disobedience na talagang pwede mong i-terminate first offense, no? First offense. However, yung mga sasabihin ng employee, sir, pasensya na, hindi ko na sunod kasi mayroon akong reason or hindi ko na basa yung memo or whatever, no? Those are not yet valid grounds for termination, no? Kasi hindi walang proof ka that it's a willful, contemptuous, defiant disobedience of a lawful order of the employer. No? So
attorney, how about if the first notice was issued to the employee already, no, for him requiring him to report to work on the first day, and then for 7 days the employee wasn't able to report to work? Can we issue another NTE, attorney, just to comply with willful disobedience clause under the labor code?
Yes, in fact,
and then subsequently terminate the employment contract of the employee.
Yes, in fact, you have another ground for termination, which is gross and habitual neglect of duty. No? Kasi kung sabihin man ni employee na hindi ko po sinasadya, sige, hindi intentional, but this constitute gross and habitual neglect. Naka 7 days na siyang hindi nagre-report, di ba? And part of his duty is to report for work. No? So you have 2 grounds for terminating the employee already. Either or, it's a valid ground for termination.
Okay, attorney, with recruitment, usually the new employee would expect that they be oriented of their job description. Okay, pag hindi ba siya na regular or he fails like the 3rd month appraisal, and because you failed to apprise him of his job description, mate-technical ka ba? Pwede ba?
The law does not specifically require orientation about the job description for the termination of an employee kung siya ay probationary, no? What the law requires is for the employer to notify the employee of the reasonable standards, no? The term used in the labor code is reasonable standards. Now, whatever that means, it can be related to the job description, it may not be, no? Kasi yung reasonable standards kasi case to case yan per company. For one company, the reasonable standards could just be attendance and punctuality. No? Kung yun lang yung basis nila, yun lang yung kinonvey. But kung related sa performance, let's say KPI, and then may mga output and results na required, no? So kailangang i-explain, of course, yung job description because it's related to the reasonable standards.
Okay. So anyway, we're waiting for our viewers to ask their questions. We're telling them not to be shy tonight. Okay. Attorney Pol is here. Okay. So Attorney Pol, what is the most common question that you have been getting this period?
This period of pandemic?
Aming
mga tanong na regarding the concept of no work, no pay. No? Kasi the principle of no work, no pay has been time and again tested during the pandemic, no? Because maraming unsure kung a certain situation ay no work, no pay o no work with pay, di ba? Kasi naguguluhan tayo because of alam natin that some company kahit na hindi nag-report si employee, binabayaran pa rin. No, so na-challenge yung understanding natin sa concept of no work, no pay. But ang masasabi ko lang as a general rule, no, and as a equitable and reasonable principle of fairness, Yan po ang general rule talaga. When an employee does not render work or any service for the benefit of the employer, ano ang karapatan niya to demand to be paid, no? 'Di ba? Ano lang 'yan? It's common sense, it's part of our sense of justice na pag hindi nag-render ng service, bakit siya magiging entitled to pay? So that still remains the general rule. However, because there's so many exception to the general rule, there's so many instances wherein nababalitaan natin kahit hindi nagtrabaho, nababayaran pa rin si MP, nalilito tayo, no? So hindi na ngayon natin malaman kung ano what in a particular situation, no work no pay ba yan o no work with pay. After giving you the general rule, which is based on principles of fairness and justice, na no work, no pay, ang dami kasing exception to the general rule. First of all, there might be a law. No? Baka may law somewhere in the labor code wherein it says na kahit hindi mag-work si employee, may pay pa rin. Maraming batas na ganyan like yung maternity leave. Hindi mag-work si employee, may bayad. Yung tinatawag nating service incentive leave, hindi mag-work si employee, may bayad, paternity leave. So there might be a law that says that even if the employee does not report for work, the employers must still pay. Like yung holiday pay, no? Yung unwork holiday pay. So may mga laws, no? So that's one of the exception to the no work no pay rule. Another exception is if there's an arrangement between the employer and the employee. Let's say in the employment contract, the employee is paid monthly paid, no? So when you say monthly kasi, bayad siya for the entire month, whether mag-report siya on or hindi. Bayad siya on a weekend, bayad siya on any day of the month, no? Because let's say executive siya, kasi kahit nandun siya sa US or magbakasyon siya, kasi mental worker siya, considered siya na nag-work, no? So bayad siya. So yan, no? These are exception to the no work no pay because by contract the employee gets paid kahit natutulog siya, bayad siya. Ganun yan. Yan yung mga executives because they're paid based on the responsibility, not on the amount of time that they spent working, di ba? So yan, if there's a contract na ganyan, bayad ka, no? Kahit may pandemic, bayad ka kasi executive ka no? So kahit nasa bahay ka lang, bayad ka. So law, contract, and then what if there is a union tapos may collective bargaining agreement, or what if there's a company policy? Kasi some company policies are very generous to employees, no? May sick leave, may vacation leave, may bereavement leave, may birthday leave. Yung law office namin, meron kaming birthday leave. O yung, ewan ko lang, may nabalita na ba kayong company na may heartbreak leave?
Nabalitaan namin yun.
Heartbreak leave.
Pero may na-heartbreak ba dito sa atin? Nag-leave ba kayo dahil yun? Okay. So,
leave yun. So depende kasi sa situation, no? Kasi halimbawa, yung company mo, startup. So, ang kaya mo lang i-afford yung mandatory leaves. Pero, let's say, may mga malalaking company, yung mga giant companies na very generous sa employee, na kahit na naka-quarantine siya, may bayad. Kahit na ECQ, may bayad. So, sometimes we compare. Bakit doon sa malaking company na yon ganon, yung mga workers may bayad kahit hindi nagre-report for work. Company policy yun They can afford. Kaya nalilito ngayon yung mga employees, they compare one company and another not knowing na iba't iba ang company policy, iba't iba ang employment contract.
Yes.
No?
Oo, kasi like for FWA, the HR actually, the P here is for the HR to brief employees kung ano yung prevailing company policy for the pandemic. Yun. So, anyway, here, Benjamin, si Benj, he's raring to go. Ang dami niyang nilista ng mga questions. Okay. So, Benj, fire away.
Sige. Attorney, ito. On anti-age discrimination law, may recruiter na naka-encounter ng, sabihin natin, mga 55 plus years old na job candidate And then there are also a series of other younger and seemingly more suited job candidates. So, in light of the anti-age discrimination law, at what point can the older job candidate be turned down, and how?
Hmm. Okay, thank you for the question, Benj, no? Ganito, no? May exception to the rule naman, no? Ano ba ang sinasabi ng anti-age discrimination law? No, discrimination at any age, no? Whether you're discriminating against a younger applicant or a younger
Young.
or an older, no?
Hmm.
Or a middle age, no? So walang specific, no, kung you're discriminating against old, young. So ano ba ang sinasabi ng law? Ang sinasabi ng law is hindi bawal ang employer to use age as a criteria, no, in making decisions regarding employees, no. So this is considered discriminatory employment practice, no, whether hiring, promotion, in any company policy, including including retirement, no. So it's all encompassing. So if you will analyze the law, ang sinasabi lang ng law, don't use age or age brackets in making management decisions.
Okay.
So use other terms like energetic, trainable, coachable, other qualifications like years of experience, mga ganyan. Use other, wag mong katulad nung 'di ba nakikita natin sa mga classified ads, must be from 20 to 25 years old, bawal 'yon, no? So that's considered discriminatory. Must not be more than 25 years old, bawal din 'yon as a general rule. So ang sinasabi lang ng law, do not use age, yung numeric age in make management decision, no?
Okay.
Kasi you are stereotyping people based on age bracket. When in fact, bakit ka nagsabi ng age 25 to 30? Because ano bang hinahanap mo from age 25 to 30? Ilabas mo yon. Ano yung hinahanap mo? These are people who are energetic, willing to learn and achieve more in life. Mga ganun. No? So
Huwag lang fresh, okay? Parang isda eh.
Okay.
Fresh.
tanggalin mo yung age bias.
Oo.
Labas mo in the first place bakit ka may age bias. Ngayon, yun yung sinasabi ng law. However, may exception sa law na if you can find a reasonable some reason, no, valid reason to have an age specific discrimination, allowed yan, no? What you have to do is come up with a policy, a written policy, and then submit it to DOL. No? Whether it's hiring, retirement, promotion, come up with a written policy, and then lagay mo yung mga justification mo why kailangan may certain age, and then submit it to DOL. Kasi by the mere fact that you submit it to DOL, parang pinapakita mo confident ka. You are confident na meron akong reasonable basis why I am sticking to a certain age. No? So I'll give you an example. If you're a company na nagsesell ka sa young adults, no? So naghahanap ka ng model at naghahanap ka ng sales lady, salesman, syempre hahanapin mo yung target market mo. Yun din yung model mo, yun din yung mga promo persons mo is within that age bracket. So that's a valid reason for hiring employees 25 to 30 because yung target market mo eh.
Attorney, how can they submit it to DOL? Like, what form will they use?
Any form. Walang particular form. You just come up with a hiring policy for that particular position and then submit it to DOL.
Okay.
Receive mo lang, no?
So basically a letter.
With a cover letter, of course.
Oo. Tapos pa-stampan dun sa receiving officer.
Mo.
Okay.
Doing that, you are telling the world, including DOL and any employee who would complain, that you have a valid reason for making an age-specific management decision, whether for hiring, retirement, or whatever.
Okay. So we started with contracts. Okay. So Benj also has a follow-up question. What was your
Okay, on contracts, um, one is, usually meron mga ano tinatawag na non-compete clauses in contracts. So, the typical wording is, at the time of your separation, you agree not to enter or render services to organizations of similar nature that are in competition with the company that he or she is leaving. So is it legal or enforceable?
Mm. There have been several decisions of the Supreme Court already regarding non-competition or non-compete clauses. No? So sabi ng Supreme Court, valid yan, kaya lang may mga certain criteria. Kasi sabi ng Supreme Court, they recognize the right of the employer to be protected. No? Kasi may mga trade secrets and things like that na naintindihan ng court that this has to be protected from a resigning or a terminated employee. No? However, sabi ng Supreme Court, kailangang i-balance mo yung right kasi the employee also has the right to find a job, to have livelihood, no, and income. Otherwise, kawawa naman si employee. So how do you balance these two rights for employer protection and for the right of the employee to live, no, to have a livelihood or gainful employment? Sabi ng Supreme Court, there are three criteria that has to be satisfied for the non-compete clause to be enforceable. First, dapat may reasonable time limit. Hindi pwedeng forever. No? So what's a reasonable time limit? 1 year is reasonable. 2 years is borderline. 3 years is probably too long. No? So in government kasi, 1 year yung standard. Sa mga resigning government official, no? Para walang conflict of interest, 1 year ban. There's a 1 year ban. So we can stick with the 1 year or less as safe. No? Second, sabi ng Supreme Court, dapat may geographical limitation. Hindi pwedeng in the entire universe. Hindi ka pwedeng humanap ng employment. No? So usually may 5-kilometer radius or within the city of Manila. Ganon. Depende kasi sa ano. So a reasonable geographic limitation. And third, hindi pwedeng any company. No? You have to describe your direct competitor.
Yes.
Say, hindi pwedeng all restaurant. No? Since nag-work siya sa restaurant, napaka-generic ng restaurant. You have to say, kung ikaw ay Filipino cuisine, di ba? So, Filipino restaurant. O kaya kung ikaw ay pizza or hamburger, sabihin mo, pizza, hamburger. You have to be very specific kung sino ang yung competitor. Hindi lahat ng business ay competitor mo. So if you satisfy those three criteria, reasonable time limit, reasonable geographic limitation, and a valid description of who your direct competitor is, then enforceable yan. Pwede mong pagbayarin si employee. And then you can also require the employee to resign.
Okay. Thank you very much for that. It came from my own experience din na marami in the IT sector who put non-compete. Maybe it's not just the IT or the tech sector also. Tama po kayo doon na there is that concern na the protection of the trade secrets. Pero ito po, attorney, when you say geographical limits, is it reasonable na sa kolonya buong Pilipinas? For example, a similar nature company, as in, direct competitor, and is the whole of the Philippines actually a reasonable geographical scope?
If the company can establish that ang operations niya at ang reach niya is the entire Philippines, then yes. Oo. Kung ang market niya, talagang meron siyang branch everywhere. No? Nagdi-deliver siya everywhere.
Mm.
Yes. Oo.
Actually, parang it has to be proven also I mean, it has to can be proven by the company. Hindi yung bila na lang nalaman ni owner, tapos biglang sasabihin ni owner na competitor ko yan so we have to sue him. Kasi minsan may ganun,
Okay.
diba? Oo.
Yan.
So, anyway, Jen. Okay, so Miss Jen Tan. Jen, are you there? You want to ask a question? Okay. So, anyway, Ken, do you have a question or do
Okay
you
lang,
have a
I'm
question?
good.
Ayan, nandiyan si Jen.
Oh,
Ayan.
Jen. Yes, Jen.
I'm good. Thank
Sige,
you.
sige.
Okay, she's
Ayan,
taking down notes.
marami tayong comments dito coming from our audience, our friends din, di ba? So, tapos na yung kay Benj. Okay ka na sa questions mo? All good? Nakamute ka, man.
Possibly marami pa, but let's give weight dun sa
Sige. Bigyan
alam ko
na.
marami sila mga concerns especially in
Sige.
this particular period. Oo.
Sige pare. Sige. Si
Okay.
Jelly Navarro typed her question in. Sabi niya, if an employee is not cleared yet and made a request for employment certificate, is it legal to put colatilia? Tama ba? Colatilia,
Yes.
not quote unquote, not cleared and with pending case in COE. Kasi I searched this in HR groups. However, there are yes and no answers regarding this matter. So yun yung question niya. Yeah.
Okay. Thank you for that question. Kasi there is no template for certificate of employment, but merong minimum required contents. Ngayon, yung additional content, that depends from company to company. Wala kasing, hindi naman bawal. Hindi bawal na maglagay ng mga remarks. Hindi bawal na maglagay ng mga disclaimer. However, if the remarks that you put are, of course, derogatory against the employee, you are inviting a potential labor case. So, assuming gusto mo talaga maglagay ng derogatory, let's say with pending case with the company, accountability, dapat ready ka na it is possible, patawag ka ng dole or ipatulpo ka. Kasi you're inviting a potential grievance or conflict. So the employee would feel aggrieved by your derogatory remarks. So talagang dapat ready ka, And if you are not ready for that, then I suggest be more diplomatic. There's a diplomatic way of stating that the employee has some accountabilities with your company, So ito yung suggestion ko, Although hindi bawal, There's no prohibition unless libelous, Kasi pag libelous yan or defamatory, pwede ka pang malibel, So just make sure hindi libelous. Now, ito ang suggestion ko. Instead of remarks, maglagay ka na lang ng disclaimer. So, lagay mo doon sa baba, this certificate of employment is not a clearance. Di ba? Pag sinabi mong hindi clearance yung certificate of employment, ganun na rin yun. Iisipin, humingi ka ng clearance sa company mo. Kasi hindi pala clearance tong certificate. Kasi ano bang required content ng certificate of employment? Sasabihin lang naman doon yung service, kung kailan ka nag-start, kung kailan ka nag-end sa employment mo, ano yung mga job na nahawakan mo. Yun lang yung that's the basic required content of a certificate of employment. Hindi naman required na pag nag-issue ka ng certificate of employment, it implies na cleared na si employee. A certificate of clearance and a certificate of employment are two different documents. So since ganun yan, The first disclaimer na pwede mong ilagay sa Certificate of Employment, this Certificate of Employment is not a clearance. Period. Second disclaimer na pwede mong ilagay dyan sa Certificate of Employment, this Certificate of Employment is not a certificate of good moral character. Third na pwede mong ilagay, this Certificate of Employment is not an endorsement for any job application. Oh, di ba? So, ibig sabihin, if the employee wants to get a clearance, kailangan niya mag-apply ng clearance separately.
Oo.
Gusto niyang humingi ng reference, letter of recommendation, hihingi siya ng letter of recommendation. Because it's not a certificate, it's not a letter of recommendation. It's just following the requirements under our existing regulation. Ano lang ba ang kailangan mo ilagay dyan? A start and end date of employment and the positions and description of the job that hinandle ng employee. Ganun lang.
Kasi natatakot sila, attorney, kasi baka sabihin, lalo na yung may pending cases, okay? Sabihin na, kaya may COE na ako, so cleared na ako dito sa kaso ko. Yun ata yung sinasabi ni Jenny. Kasi may mga employees na, di ba, ini-investigate pa lang, tapos nag-awol na, tapos pinapakuha ng new company nila ng COE. So, parang ganun. And then, sinasabi nila na kailangan bigyan nyo ako ng COE kasi nasa, department order ng DOLE.
Yes, required, mandatory po na magbigay dapat ang employer ng COE. Ang nakalagay nga sa labor advisory within 3 days from request eh.
I see.
But yun nga, we have to limit the effect of the COE. Hindi naman yan clearance.
Yes. Okay. Yun. So, ito, attorney, bumabalik na naman tayo sa recruitment. Okay. From Marilu Jacinto. Attorney Paul, kindly explain po about labor piracy. What if the former manager recruited employees who are still connected with the company? Is the former manager, can he be held liable?
Ang tawag po dito, there are post-employment restrictions, no? Non-compete, non-solicitation, sometimes they call it no poaching or
Poaching, yeah. Oo.
They call it piracy, no? So maraming terminologies diyan. So, kung wala po kayong nilagay na post-employment restrictions, no? Ang tawag dito kaya ang tawag sa kanya post-employment restrictions kasi kahit na wala na kayong employer-employee relationship, this obligation is still intact, it still remains, no? Yung non-competition, non-solicitation, confidentiality, non-disclosure, these are the varieties of post-employment restrictions. Kung wala po kayong post-employment restrictions, as a general rule, hindi nyo po pwedeng idemanda si former manager, and even the employees na sumama sa kanya, hindi nyo rin pwedeng idemanda because it's their right to resign.
Yeah, and seek maybe a better employer. Baka ganun yun.
Oo.
So, ito, Attorney Paul, okay, during employment, madami tayong mga disciplinary actions, okay? There was this question from Mr. J.B. Valera. I think this has something to do about yung equipment, okay, na inassign sa kanya, pinon ng employee. The employee was given a laptop and the employee pawned it, okay? So, the company found out about it. Okay, so the first question is, is this an offense? Can this lead to termination? Because theft?
Yes, that's a serious, I consider that as a serious misconduct, but hindi pa naman theft.
Nireturn naman ng employee kasi natatubos naman ata niya. Pero the act kasi siguro is pinon niya yung laptop na it wasn't his in the first place.
that can fall under serious misconduct, no? And that's in my opinion, that's a valid ground for termination. Kasi kung hindi yan serious misconduct, it's a willful breach of trust, no? Kasi in-entrust sa iyo ang isang company
Asset.
property, asset, like a laptop, and then sinanla mo, di ba?
Oo.
Misuse.
Yes, that can fall under either serious misconduct or willful breach of trust.
Kasi may natandaan akong hinandle ko yan. I think yun yung uso yung cellphone, pinupon. So, kaya pala hindi siya matawagan kasi pinon niya yung cellphone. Yun. Hindi ko alam. Hindi naman kami nalilate sa sweldo. So, pero pinatawad siya ng company but he was like given a warning. Ganun. Parang ganun na lang ang ginawa. Okay. So, anyway, Attorney Paul, madaming nalilito kasi sa mga terms na to. Kasi this is a time when companies are probably mulling what to do, okay, with after 7 months of the pandemic, they're mulling what to do. So, what is the difference between retrenchment and declaring redundancy? And a follow-up question is, kahit ba nagbigay ka ng separation pay, pwede ka pa bang habulin sa dole ng employee?
Okay, thank you for those questions. Maraming nalilito regarding retrenchment and redundancy because these terms, itong retrenchment and redundancy, has a technical definition, has a specific definition under labor law. But if we research sa dictionary, malilito ka kasi may generic definition siya, no? May generic definition ng retrenchment and then may technical description siya under our labor law. So if you use retrenchment in the generic sense, it's different from the technical sense sa ating labor code. So that's the first reason kung bakit may confusion. Same with redundancy. Redundancy, you can check with the dictionary. There's a definition, but under our labor law, may technical definition then. So, first of all, if we want to be clear, let's discard muna yung dictionary meaning ng retrenchment and redundancy and go to the technical meaning under the law, no? So, i-distinguish muna natin yon. Kasi when you say retrenchment, there's a temporary retrenchment, there's a permanent retrenchment. Anytime na magbawas ka ng tao, you can generically call that retrenchment or reduction, di ba? Redundancy, anytime na there's a duplication or excess manpower, you can call it redundancy. Kaya nga, very related yan yung retrenchment and redundancy, kaya confusing. No, so, okay, so diniscard na natin yung generic definition, we go to the technical. So dito naman sa technical definition, what's the difference? The main difference why we have to know to distinguish these two is magkaiba yung kanilang separation pay. If you terminate an employee based on retrenchment, ang babayaran mong separation pay mas bababa, 1/2 month for every year of service. But not lower than 1 month salary. 1 month pay, no? Pag redundancy ang gagamitin mong reason for terminating an employee, the separation pay is 1 month pay for every year of service. So, ang laki ng diferensya, no? 50%. So, retrenchment, you save 50% sa redundancy, buong buo, 1 month pay. So, sasabihin ngayon ng mga employer, teka, gusto kong makatipid, no? Kasi kulang ako sa pondo, kaya nga ako nagbabawas ng tao, gusto kong mag-survive. So, dito na ako sa retrenchment. So, yan. So, because retrenchment allows the employer to give a lower amount of separation pay, mas mahirap yung mga requirements, no? Mas mahirap, no? Sa redundancy kasi, you only need to prove that the position of the employee is abolished, no? What do you mean abolish na yung position? Hindi na kailangan ng negosyo mo, ng business mo. So, nag-reorganize ka, naggawa ka ng bagong organizational structure, positions, and the number of employees na kailangan mo for that particular position. So, after coming up with a new organizational structure, mayroon kang organizational chart, functional chart, at saka number of employees required for each position, lumabas na may mga position na hindi na kailangan, no? Excess positions, no? Because under your new, compared to the old company organizational chart, may mga excess position. Tapos itong mga tao occupying these positions, hindi mo na sila mahanapan ng bagong position within your new organizational structure. Wala na, no? Wala na silang mapaglagyan. So since wala na silang mapaglagyan sa existing organizational structure mo, they are considered as redundant. At ina-allow ka ng law ng ating labor code to permanently lay off these excess employees by paying them, by giving them a 30 days notice prior to the effectivity of the termination, as well as separation pay of 1 month salary for every year of service. Yun lang yun. So ano requirement to prove redundancy? You just have to show your old organizational structure and your new organizational structure and tell the labor officials under my new organizational structure, which I believe is good for my business, may mga excess employees ako that I cannot accommodate anymore in my new organizational structure. Yun lang ang kailangan mo for a redundancy. Of course, good faith. Kailangan may good faith ka. Hindi ito fake redundancy, no? For retrenchment, the requirement is much more difficult, no? You need to prove that you are doing this to avoid closing down, no? Retrenchment is about survival and sustainability of the business. Redundancy is about becoming cost-effective, cost-efficient, no? Retrenchment is about survival. You're saying you're financially distressed. Pag hindi ako nagbawas ng employee, malamang magsasarado ako. I'm probably going to close down the entire business. So instead of all my employees suffering and losing jobs, might as well some employees lose jobs to save the business and to save the jobs of the remaining employee. That's the essence of retrenchment. No? So you have to come up with documentary proof that that is really the case, that it's a matter of survival and sustainability of the business. No? So you have to show na with your financial statement na talagang luging-lugi ka na, ang dami mong lugi. Or kung hindi ka pa nalulugi, that may parating na pag hindi mo pinaghandaan yon, talagang sarado yung business mo. Tiklop ka, no? So, how do you prove that? Financial statements or financial projection? If it's going to be a future loss that you expect to take on, no? Let's say may nag-terminate yung pinakamalaki mong kliyente, terminate yung service contract mo. 'Di ba? Na 50% of your revenue nanggagaling dun sa employee, sa client na 'yon, no? So ibig sabihin kahit hindi pa nagte-take effect yung termination of the service agreement, no? Because you know that's going to have a major impact on your revenue. Kahit hindi mo pa nararanasan yung losses, no? Pwede ka nang mag-retrench ng employee before it happens. But you have to show proof na ito, na-terminate yung you have to show proof na 50% of my revenue comes from this big client. Kahit na positive, kahit na kumikita ka pa doon sa previous financial statements mo, okay lang yon, no? As long as you can prove. Now, pwede namang pass, no? Pwede namang pakita mo yung past records mo na if this trend continues, then I would have to close down because ubos na ang aking kapital. No? So, that's the requirement. If you cannot do that, then hindi ka pwedeng mag-retrench.
Attorney kasi, yung during that process, okay, so you would have to make an announcement to employees, okay? at some point, I think sinabi ng DOLE, as long as mag-agree, you have to talk to your employees. And kailangan mo i-explain sa employees. And as long as mag-agree sila, and even in the establishment form, there has to be an employees representative na mag-sign. Okay? Kasama ang retrenchment doon. Kailangan ba mag-agree 100% ang lahat ng employees doon sa decision mo? Do you have to seek their approval to retrench?
No, it's not a requirement. The signature for the employee representative is for alternative work arrangements, like compressed work week and other flexible work arrangement, but not for retrenchment. Kasi ano yan it's a purely a management decision.
I see. Oo. So, attorney, nagbayad ka na ng separation pay. Pwede ka pa ba habulin ng employees mo?
Yes, definitely. No, payment of separation pay is not a guarantee that there will be no labor cases. No, I have handled several labor cases wherein the employer has paid separation pay and the employee has filed. Dalawa kasi ano pwedeng mga i-file na labor case ng isang employee who has received separation pay. One labor case na pwede niyang i-file is kulang pa.
Oo ga.
Kulang pa, no? Tinanggap ko lang ito kasi itong available pero sa totoo lang I believe I deserve more. Yan. Pwedeng i-file ng employee. Another case na pwedeng i-file ng employee who has already received separation pay is illegal dismissal, no? Kasi kung hindi totoong may valid ground for retrenchment or redundancy or any authorized cause under the labor code, kasi pwedeng walang good faith or fake lang, no? Pwedeng mag-file si employee. Let's say, for example, sabihin ng employer, meron akong ground for retrenchment or redundancy, and then after na umalis na si employee at nabayaran ng separation pay, biglang nag-post si employer ng we are hiring.
Oo nga, kasi usually madami kami natatanggap na question. Nag-retrench sila, tapos mag-hire pa ng isa or dalawa. So, kailangan ba na hindi na pag-hire? Ano ba ang doon? Ang technicality doon?
Case to case naman yon. Ang importante kasi is the good faith, no? And the genuineness of the retrenchment and or redundancy. No? Kung yung i-hire naman ng employer is for another job, let's say a job na hindi naman qualified yung mga employees na na-retrench or na lay off, pwede naman yun. But if it's exactly the same job, no? Parang di ba? Lokohan yun, no? Sabi mo, redundancy, tapos exactly the same job. Sasabi mo, bigla.
Same title. Terminate si driver A. Okay. The next day, mag-hire ng driver B. So, obvious na yun.
Obvious yun na bad faith yun, no? Na hindi totoong may valid ground for a retrenchment or redundancy. You just want the undesirable employee to leave, no? In exchange for separation pay. Kaya ito nga isang situation, no? So iniisip ng ibang employer, meron silang undesirable employee. Wala silang mahanap na valid ground to terminate the employee. So opera na lang natin ng separation pay para umalis na, no? So sige, sasabihin nila kay employee, resign ka na, ito na lang separation pay minsan the employee did not resign, hindi siya nag-resign, no? So pumirma lang ng quit claim at saka acknowledgement receipt ng separation pay, tapos magpa-file na ng labor case. Allowed po yun, no? And most probably, the employee will win. Kasi wala ground. Anong technique dapat dyan? Kung gusto nyo gawin yan sa isang employee, don't forget to ask for a voluntary resignation.
Ito nga, attorney, there was a question here. I was advised to resign. Isn't forced resignation illegal?
Ah, tinutukan ka ba ng barel o kutsilyo, 'di ba?
Mm,
Yung
yun.
kasi, how do you, paano masasabing forced na resignation?
Kinonvince siya, mag-resign ka na lang.
Kung na-convince ka pala, di hindi na yun forced. Nagpa-convince ka eh. Di ba?
Ayun.
If you were convinced or persuaded and you were actually convinced and persuaded, then it's not a forced resignation. Walang illegal dismissal yun. You decided to resign. No? Forced resignation is yung talagang kinaladkad ka na wala kang choice. No?
Oo.
Pag nag-usap kayo, please resign ka naman, no? Tapos naawa ka, sige nga, magre-resign na po ako.
Kasi
Forced resignation.
I have a follow-up question for the person who asked that. Kasi yung scenario, kasi there are some employees, okay, hindi na pumapasok, okay. So, ano ba yung situation? Ano ba yung particular situation mo when you were advised to resign? Kasi hindi ka na makapasok or I don't know. Please elaborate on the details lang. Yun. But yun nga, yung forced resignation, kasi sabi ng minsan kasi nangyayari yan. In the past, tinatanong ako sa disciplinary action, ma'am, may chance ba akong maabsuelto? Yung dito sa, kasi usually yung mga kaso nila is absenteeism. Daming beses na. Okay, nasa fourth offense na kami, okay? Absenteeism and tardiness. So, ma'am, mako-forgive ba ako dito? May pag-asa pa ba? Paano naman ang sasabihin ko, fourth na nga, di ba? Fourth offense na tayo. So, for sure, hindi ka ma-absuelto dyan kasi meron ka ng track record, okay? Na absent ka na absent, tardy ka palagi. So, sa tingin mo, ma'am, mag-resign na lang ako, mas okay. Nasagutin ko, sa tingin ko, mag-resign ka na lang. Pwede ba akong, dyan, mabalikan, attorney?
Depende kasi sa context ng inyong conversation, no? As I was saying, if it is a voluntary decision of the employee, even though there's a persuasion on the part of the employer, there is no forced resignation, illegal dismissal, or constructive dismissal. Kasi as long as the employee is given a choice, whether to fight it out, no? Sige, I'll face the music, sige, isusugal ko, no? Lalaban ako dito na I'll defend myself during the due process proceedings na baka naman maabsuelto ako. As long as you give the employee the option, you have the option to resign and you have the option not to resign and just face the music, no? So, ang risk mo dyan is if you do not resign voluntarily is pag nag-decide yung committee na i-terminate ka, may record ka na terminated ka. Diba? Pag nag-voluntary resign ka, so since nag-resign ka, diba, pwede nating i-case close na to. Of course, kung may accountability ka, that's a separate issue. But insofar as this disciplinary proceeding is concerned, since voluntary resign ka, we'll just have to close this case, no? And then ang lalabas sa record, you resign voluntarily instead of being terminated. As long as you put it that way and give the employee the choice, no? Kahit na meron kang konting advice na sa palagay ko, maganda mag-resign.
Actually, this particular question, I think she came under conflict with some coworkers and she's being advised to resign na lang.
Basta binigyan siya ng option, it's not a forced resignation.
Okay. So parang you have a choice that you can face the music, go through the administrative case or go through whatever. Okay?
Kaya nga ang suggestion ko, para hindi ka masabing na nag-force resign, mas maganda nga in writing.
Okay.
Kasi in writing, you can control the script, no? Pag sinabi mo sa employee na, let's say during the disciplinary proceedings, actually, you have a choice for a grace, no? by voluntarily resigning. And you have also the choice to continue with the proceedings, present your evidence and your witnesses, and we will give you a fair hearing and we will decide according to the evidence. No, we will be fair to you. So it's your choice. Do you want a graceful exit para
Ayun.
itong proceedings na to or not? You put that in writing. Kahit na demanda ka, you show the written that you're giving the employee the option and then nag-resign siya. How can she say or he say that na pinor siya mag-resign when clearly in writing he was given a clear choice? Diba? Whether to avail of the graceful exit or to continue with the disciplinary case.
I think that's the key word. Offer the person a graceful exit to save the name, so save the reputation, diba? Parang that's the parang intention, I think, of some HR managers. Kasi kung masyadong masama yung administrative case, like it's not just tardiness pero if it's theft, it will not end with the administrative hearing. So any follow-up questions from this panel here in the Zoom room? Okay. Attorney, nagwo-work ba yung mga quit claim na yan?
Oh no.
May visa ba yan?
There's a lot of misconception about quit claims. Quit claims has become a standard protocol for employees who are leaving, for whatever reason, whether they got terminated or they resign, But there is some high expectations about quit claim that we have to ibalik natin sa reality, Ilagay natin sa reality. First of all, let's define what quit claim is. So, a quit claim is a form of waiver. It's a waiver of a right. Now, when you say waiver, a person, or in this particular case, an employee is waiving a right. May wine-waive siya. Pag sinabing waiver, ibig sabihin, sinusurrender niya, ginigive up niya. Kaya nga tawag dyan, quit claim. May ginigive up siyang karapatan. And what is this right that the employee is giving up? It is the right to sue. Right to file a labor case. Now, all citizens, kahit nga foreigners, basta nandito sa Pilipinas, have the constitutional right to sue. To whether meritorious, whether may kwenta yung kanyang demanda o wala, basta may right siya na magsampa ng demanda. Karapatan niya ng lahat ng tao dito sa Pilipinas. You have the right to sue, whether manalo ka o matalo, basta makapag-institute ka ng case, that is your right. So that is the right, that is the subject matter of a quit claim. So sinasabi ng employee na pag pumirma ako dito sa quit claim, yung right ko, yung aking constitutional right to sue my employer, my previous employer, I'm already surrendering that. I'm already quit claim, Wine-waive ko na yan, Hindi na ako magdidemanda. Okay, so yun. But for that quit claim to be valid,
it's 10 o'clock.
Kailangan kasi may valid consideration, Kasi right yun in exchange for that giving up of the right to sue the employer, ano ang naging kapalit, Di ba kailangan reciprocal yan? What's in it for me? If I'm the employee, what's in it for me? Okay, I'm going to give up my right to sue you, but what's in it for me? So that's
Kaya ng separation pay.
what's it? Hindi, yung separation pay is based on the law, whether the employee signs a quit claim or not. He's entitled to that, Yung final pay niya, isipin mo yung final pay, pinaghirapan niya, pinagpawisan niya yan, pinagtrabaho. And that's based on contract and company benefits. Whether the employee signs a quit claim or not, the employer is...
Ibigay yun.
So, anong ibibigay mo sa akin, Mr. Employer? I'm the employee. Pinapapirma mo ko ng quit claim. Yung final pay, kahit hindi ako pumirma ng quit claim, ipapadole kita, babayaran mo ako ng final pay ko. And I don't have...
Yan na lang recommendation. You are the best employee we've ever had. Sign the quit claim.
So dapat there must be a valid consideration for the employee to
What
kung
is this valid consideration, attorney?
it can be money, it can be a mutual quit claim. No? What do I mean by mutual quit claim? That the employer will also not file a case against the employee, assuming nag-audit si
Ah,
na may mga kalokohan pala tong si employee, hindi na rin niya pwedeng habulin si employee. That's a mutual quit claim.
kumbaga, kasi the quick claims that we see, they're one-sided.
Yes. One-sided. Kaya hindi nire-respeto ng DOLE ang quit claim. So tingin pa lang nila, scrap of paper, it's a one-sided na pabor lang sa employer.
So
Dapat
the is the employee will not sue the employee or claim anything further, and then the employer also parang dapat nakalagay sa document.
That's a mutual quit claim. Pwede namang hindi mutual quit claim, but you have to give something to the employee, no? Like a sum of money as
Additional to the final pay and the separation pay.
Yes. Yung nagbebenta nga ng boto, binabayaran mo ng 500 pesos or 1,000 pesos. Yung nagbebenta pa ng, di ba, the right to vote. Binibili yan ng mga traditional politician 500 pesos, 1,000 pesos, di ba? Isang sako ng bigas. Yung nagbebenta ng boto, at least yung mga traditional politiko nagbabayad. Yung employer, anong bayad mo? Ito nga, binebenta na nga yung kanilang right.
Can it be like a placeholder, like 100 pesos?
Pwede naman. Reasonable yung consideration. It's not specific amount, but it has to be reasonable.
I see. Okay, so that's the first. Okay, so I learned something new from you. Okay.
That's just one of the requirements for the valid quit claim. Another requirement is dapat voluntary and knowingly. No? Voluntary is kasi sasabihin ng employee, kapit ako sa patalim, kaya pinirmahan ko yan. Hindi ko naman talaga gustong pirmahan, but kung hindi ko pirmahan yan, hindi nila i-release yung final pay ko. So sasabihin ng employee, hindi talaga voluntary kung pinirmahan yan. So the employer has to prove that it is a voluntary acceptance of the quit claim. No? Ang daling gumawa ng kwento No? Hindi i-release yung aking final pay kung hindi ako pipirma ng quit claim. Ginawa nilang requirement yan before I can receive my final pay. So I'm forced to sign it. So sabi ng employee, hindi ko talaga So it's an invalid quit claim already because it's not signed voluntarily. Third, knowingly. Naka-English. English
Oo nga.
Hindi marunong mag-English yung employee kasi
Oo nga, yun yung palagi sinasabi sa kaya tinatagalog ko yun
so voluntarily, knowingly, and with reasonable consideration. Those are the requirements. Ngayon, kung wala yung mga ano ang silbi ng quit claim? Quit claim, gusto mong i-lower down yung expectation mo, na lang yan, acknowledgement receipt. Lowering down your expectation, kasi the employee might still file a case against you kahit anong pinag-usapan nyo, magpa-file pa rin yan ng case, lalo na kung may bulong-bulong, may mga nag-a-advance.
Kasi attorney, mahirap ang, ngayon, nauubos na yung separation pay.
So at least, ang pinaka-value ngayon ng quit claim mo? It becomes an acknowledgement receipt.
I see.
Para hindi siya pwedeng mag-double claim.
Oo. Ito, attorney, somewhere in the questions, okay, so, na-terminate siya, okay, pwede pa ba siyang mag-apply daw ng retirement benefit?
Sabi ng Supreme Court, in their in jurisprudence, decisions ng Supreme Court, it is possible for the employee to have a separation pay and at the same time retirement pay. Possible yan. There are situations wherein an employee can claim both. This is rare, but the Supreme Court says it is possible.
What conditions must be met?
Kasi sabi ng Supreme Court, itong inanalyze nila, iba kasi ang basis for retirement pay at iba ang basis for separation pay. If both this situation happens at the same time, then the employee can receive both. So ano bang basis ng retirement pay? The employee works for at least 5 years and nasa retirement age siya. Yun yung
Kung bata pa, hindi pa pwede.
Oo. And then separation pay naman is if the employee was separated because of redundancy, no, or retrenchment. So iba kasi ang requirements niyan. So sabi ng Supreme Court, if both these requirements happen at the same time, na nag-work siya for more than 5 years at retirement age siya, and at the same time, all these requirements of redundancy or retrenchment is also present, then pwede niyang ma-receive both.
Alam mo, yung attorney, itong mga sinasabi mo, parang magiging employee na lang ako. Ang dami ko palang makiklaim. Di ba, Ken? Okay. So anyway, ito attorney, okay. So babalik tayo, okay. Kasi madaming okay, may nagtanong okay, I guess nasagot na to, but why do we really have bakit naging practice nga magkaroon ng quit claim? Ano ba ang why should we execute it if it has no value?
First of all, marami pa rin namang may word of honor.
Okay.
No, kasi when people sign something, it means something. When a person puts his signature on a document and undertakes na quits na tayo, no? It has some value. The word of honor, that's the first thing, no? And deterrent din, 'di ba? Deterrent. So pag alam na nung employee, pumirma na kasi ako eh. 'Di ba? Okay na 'yan, no? I'll just move on, no? So that's the first reason. Second reason is of course the value of the acknowledgement receipt para hindi na siya mag-double claim. Assuming mag-file pa siya ng labor case, kung ano yung na-receive niya, hindi na niya pwedeng i-claim pa uli yun.
Okay. So parang it's like a documentation, a form of documentation.
Yes.
So somewhere along the way, okay, so if during the middle of employment, while you're employed, okay. So what is your take on people, okay, so refusing promotions, okay. So na-promote siya, pero ayaw niya ma-promote, so ayaw niya mag-sign. Kasi some people say insubordination daw yun.
Hindi raw eh. Sabi ng Supreme Court pag promotion, the employee has the right to decline. And it's not insubordination, no? Kasi it's a reward na hindi naman mandatory or required, no? Na dapat acceptin ng employee kasi nga promotion yun eh. So the employee has to accept it. If the employee has to accept it, pwede rin mag-decline si employee, no? So sabi ng Supreme Court, it's not insubordination if it's a promotion. However, no, we have to distinguish a promotion from a temporary assignment, no? Gagawin kitang OIC.
Kasi yung iba ginagawa lang OIC.
OIC manager is not a promotion.
Acting.
Yeah, acting. It's an instruction. It's actually an assignment and it's not a promotion. So hindi pwedeng i-refuse ni employee. 'Di ba? So you have to distinguish a promotion from a
temporary assignment. So
temporary
if it's
assignment.
So that's an order, kumbaga. It's treated like an order.
Yes.
To be a promotion, there has to be, of course, an increase in pay, right?
Yes.
Okay, so that's the difference. Difference between the two.
Yung OIC, no, that's not the only difference. Kasi yung OIC, pwede namang bigyan rin ng additional remuneration, di ba? Kasi additional work yun eh. Binigyan mo na nga ako ng pinagtrabaho mo pa ako, tas same din yung compensation. So, syempre, it's but fair to give additional remuneration sa isang employee acting in OIC or acting capacity, di ba? Where does the distinction lies, no? So, the distinction is more on the what you call this, the higher level or higher rank that is bestowed on the employee.
I see. Dapat clear siguro yung company doon. Kasi minsan sinasabi, over-promoting you yung pala, ano lang. Pero ito, attorney, how about additional task in the job description? Can an employee refuse an additional task to be put in a job description?
Ah, no. But nagiging irritant kasi yan dahil sa maraming employee na uh, very fixated do sa job description. And
Oo.
for some of them they have valid reasons, no? And some, yung iba talagang makwenta lang, no? May mga valid reasons kasi may mga employee na may sinusundang career.
Mm-mm.
Ako, accounting graduate, and then I applied as accounting officer. And then later, binibigyan mo ako ng marketing job. Ang aking career pathing is to become become finance, no? So, diba, that's not part of the agreement natin kasi meron akong career path na pinapollow. Bakit mo ako bibigyan ng marketing or HR when into I want to specialize into accounting? So may valid reasons si employee, no? However, as a general rule, whether or not naka-state yan sa contract or sa company policy, the employer has a management prerogative to reorganize and reassign employees within the company. Kung ayaw ni employee do sa binibigay na bagong assignment niya, the only option of the employee is to resign. That's the general rule. However, this has become an irritant, no? And so ang best practice dyan is hiring pa lang at sa contracting with the employee, specify na that the management has the prerogative to reassign, give additional job description, change the job description of the employee from the get-go para hindi na being source of grievance or conflict. But whether or not meron, no? Yun nga lang, whether or not merong ganong provision in the contract or in the company policy, talagang natural, inherent management prerogative yan to reorganize and reassign people, transfer people. Yun nga lang, no? Iba kasi yung sasabihin mo, karapatan ko to. Yung employee, pumapalag di ba? So, there's a best practice to everything.
Okay, I'll ask the HRs here, okay? And also Attorney Paul. Kala nyo, si Attorney Paul lang sasagot. So this particular person that has been asking me this question, I will ask their questions now, okay? She's been asking me, okay, so they have a driver, okay? In the past, that driver has been helping in the warehouse, okay? Hakot ng mga gamit, okay? And then nag-retrench na. Now, company is realigning all the job descriptions. And then they're trying to make that employee, the driver, they're trying to put that help in the warehouse to carry things, okay? Now, the driver is refusing that particular task. Pero pag hindi mo naman ilagay sa job description, ginagawa naman niya. Okay? Pero ayaw lang niya mailagay sa job description kasi hindi daw yun yung in-applyan niya. Okay? So what can she do to the driver? What other means or what other interventions can she resort to solve the problem?
There are various approach, no? But since I'm a lawyer, ang legal approach dyan, of course, is disciplinary. No, kasi that can be considered as insubordination by exercise of management prerogative. Hindi limited or hindi nababox in si employer na kung ano yung hinire niya si employee at yung original job description, hindi ibig sabihin hindi na pwedeng baguhin yon, no? As long as it is related to the work, no, and the employer is acting in good faith, and there's a business exigency or business need, no, hindi naman na there's no oppression on the part, no discrimination on the part, talagang in good faith si management, talagang ano po yan, pwedeng disciplinary action yan for insubordination. Pwede niyang memohan. That's the hard line approach. But there's of course the HR or the soft approach. Explain na lang kay employee ang dahilan, no. Kung makuha mo kasi kung mapaintindi mo kay employee, mas mabuti. Kasi kung gagamitan mo ng dahas, no? Baka isabotage siya, baka mamaya yung gamit mo sira-sira. Di ba?
Kasi ako may nakikita kasi ako dyan, attorney. Sa warehouse kasi, baka ayaw, kasi sinabi ko sa kanya is, tanungin niya kung bakit ayaw niya talaga. Kasi yung in the past, may mga na-assign sa warehouse from my other companies, okay? Ayaw nila kasi pag may nawawalang gamit, automatic deduction lahat. So, feeling ko yun yung rason kung bakit nire-refuse niya makonect sa warehouse. Kayo, Marco and Bench, what's your take?
Okay. For me, hindi pa ako nakapag-handle kasi ng personnel for a warehouse or a logistics company. So tech yung yung sector ko. So but if I'd be given, for example, the chance to decide on that. So number one, tulungan niya kami because tutulungan niya sarili niya. Yeah, in the context of business exigency, especially if for example ngayon, we want to save the company, but we need help in these areas. We could not trust anybody but you. You know the goings on. Kaya o paano, sana matulungan mo kami. Because if things don't move by themselves, edi natatakot ako para sa kanya. Yung iba makakasurvive pero para sa kanya, baka siya yung mawala ng opportunity and there might not be another opportunity. Yun.
How about you, Marco?
Tackling the issue. First is issue a disciplinary action, primarily because my practice is into employee discipline, no? And second is to buy the employee or provide another compensation because there is another task that was assigned to the employee. So you provide another premium to that particular new task given to the employee, though the task was already exercised by the employee prior to incorporating that into a document. So that's my take on the issue.
Okay. There is okay. So if there's a comment here, this is from Jen. If there is no catch-all provision of any other relevant task as may be assigned, can this be part of can this task under that was performed under from time to time, can that be part of performance appraisal? And then can you explain or can we entrust him with that task if it is just like be assigned from time to time? I think that's kasi business exigency, parang wala na, kailangan ng katulong doon. So the situation was nag-retrench yung company. So all hands on deck, parang the company needs all the help that they could do. So that's why they're realigning the job description. Anyway, attorney, what if, okay, nag-issue ng NTE, pwede ba yung NTE ang deadline 24 hours lang?
That will be considered a violation of procedural due process dahil sa according to the Supreme Court and the regulation issued by the Department of Labor, minimum of 5 calendar days ang period for the employee to submit the written explanation. Why bakit ang haba, no? Bakit 5 days? Kasi to give the opportunity for the employee to consult a lawyer if necessary, or ask advice from anyone, talk to witnesses, gather documents and evidence on top of the work that he is doing for the company. Kaya 5. Kaya sabi ng Supreme Court, the reasonable period is 5 calendar days. Now, sasabihin nyo naman, ang tagal naman, 5 calendar days, gusto ko na ng sagot kaagad-agad. Now, you have to distinguish between the first notice in the disciplinary process and the fact-finding memo. No? So kung magpa-fact-finding memo ka, let's say you're a manager, you're a business owner, and you just want to know what happened, you can tell the employees to submit incident reports within 1 hour. No? Gusto mo 24 hours, pwede rin. Ano pinapasubmit mo? Incident reports. So, allowed yun because it is not yet part of the disciplinary process or even the due process. You are just conducting a preliminary investigation or a fact-finding, data gathering, no? So you are interviewing people and you are asking people verbally or in writing to submit what they know about the incident. No, yeah, that you can do that, no, within 1 hour, immediately, right here, right now. Drop everything, prepare the incident report. Pwede yun, no? Kasi alam nyo ba kung anong laman ng isang notice to explain or yung first notice when you start the termination proceedings? It's a formal charge. Actually, it's a formal charge. It's not just a simple memo. You are charging the employee of violating certain company policies or committing certain violations that would, if the employee is found guilty, he may be terminated, no? So it's like it's a formal process. Kaya nga yung ibang company, they do not want to use notice to explain. No? They do not want to use kasi napaka-casual. Napaka-casual ng notice to explain. They want to change it to notice of administrative charges. Just to emphasize that this is a formal proceedings. Kaya nga 5 days ang binibigay, no? So, kung gusto mong immediately, wag kang magpa-notice to explain. Magpa-submit ka ng incident report.
I see. How about return to work? Okay, so in 24 hours, return to work. Is that valid?
Return to work within 24 hours depende sa sa exigency at saka sa efficiency ng notice mo.
Oo. Kasi pag snail mail, baka hindi yan. Depende kung ano. Okay. Kasi iba yung return to work sa notice to explain. Okay. Iba yun. Okay. So, anyway, how about some graphic designers? Okay. They just want to hear it from you, attorney. Their works, okay, intellectual property daw nila yon. If they resign or they get terminated, can they sue the company for that?
Under the laws of intellectual property, no, the owner is the creator. So whoever is the creator is considered as the owner. And once the creation of the intellectual property happens, the right of the owner already exists. No? So, yes, ownership nila yan. That's why employers who are employing creatives, no, yung mga creative people, has to have in their contracts, in their employment contract, a provision regarding ownership of creations and other intellectual property.
How about IT, software programs?
Yes, kasi that is copyrightable kasi yan yung software. A software you can register the software program under the copyright law. So whoever do the program, the coding, kung siya ang creator noon, siya yung owner. No, that's the general rule. unless there is a provision in the contract that they have regarding ownership.
I see. So they better be careful with their employee contracts.
Yes, oo. Hindi nila pwedeng sabihin automatically, hindi, ano yan, company property yan. Without a contract, the employee can claim na property niya yun because
I
that's
see.
intellectual creation.
Oh, kaching-kaching dami ng mga cash value to. So I'm just making light of the situation. Okay. So any more follow-up questions from you, Marco, Jen, and Bench?
I don't know if this is a follow-up question, but somehow related dun sa earlier question. What are your thoughts on employees moonlighting? And so parang freelance, I believe they call it freelance now. And then they offer the same services or similar services being offered by the company where they work in.
Okay, so definition of terms. So moonlighting, let's have a clear definition. But before that, ang masasabi ko lang is in the Philippines, there is no law prohibiting an employee from having another employment or multiple employment. Wala. No? So an employee, let's say I'm employed in one company, as a general rule, I can be an employee of another company. I'm not violating any law or any contract or any company policy.
Seems like it's a preference lang ata of business
Even
owners.
like in the US, no, almost everyone have a second job.
Yes, correct.
Ba? Part-time sila, barista sa gabi, mga ganun. So, in the Philippines, allowed rin yun, no? So, it's up for the employer to, if they do not want employees to have another employment outside, it's up for the employer to come up with an employment contract or a company policy that is binding and which prohibits the employee from doing so. No? Otherwise, okay yun, legal. Hindi mo pwedeng kasuhan si employee.
If you're silent, if the contract is silent,
then the employee can have another job. No? So, ano yung mga lookout ng isang employer? No? So, by the way, pag sinabi mong moonlighting, it's different from conflict of interest.
oo. Kasi I think, kasi yung moonlighting, like for example, different talaga. Like, meron siyang day job, tapos ano pala siya, celebrity, actress pala siya. Nagva-vlog pala siya. Yun.
So, you have to define, kaya nga sabi ko, i-define natin ang moonlighting. Is there conflict of interest? Kasi kung walang conflict of interest or wala namang probability or danger of any leakage of confidential information, di ba, or trade secret, then walang masama sa second job or multiple jobs. So, ano mga lookout ni employer? So, you have to look at conflict of interest situation and protection of your trade secret and other confidential information. So, you can, for example, ngayon, maraming mga nalilay off for 6 months or even more, and they have to find some livelihood, no? So, ano out mo dyan? As an employer, wala ka maibigay na trabaho, diba? Sa employee. Tapos hindi mo pa naman ma-retrench, hindi mo mabayaran. Floating. So, hahanap ng trabaho yan, ng gig or whatever, no? So, you have to remind the employee na although you can find a business or a livelihood or even a temporary employee to get you over, to tide you over this difficult period, may we remind you of your obligations. Number 1, no, we have trade secrets, so or may non-compete tayo, so hindi kayo pwedeng magtrabaho sa competitor or any job that would be magkakaroon ng leakage ng trade secret and things like that. So you give the employee the guidelines. Maghanap kayo ng other livelihood, but these are the prohibition. Kasi employee pa rin sila eh, di ba? And if they violate the non-compete, if they violate the non-disclosure, violation yun, kahit naka-floating sila.
Oh, kasi example lang, attorney. So when we initially, kasi nag-reduce work hours kami, okay. So but we specified kung kulang yung sahod nyo, they can have another job, okay. But okay, because we're a payment processing company, yung mga secrets, okay, like credit card information, etc., cannot be leaked out, even to their relatives, okay. So yun. But they can, for example, have like a gig. Okay, so pwede silang mag-sell ng insurance, pwede sila. Kasi ang thinking namin noon is we better allow them kasi syempre, we bet at least they will be able to talk about it with us. Alam namin kung ano yung ginagawa nila. So that's another way of looking at it. Okay, imbes na pagbawalan, you can just allow them a little freedom so that you know what they're doing. Just like a suggestion. How about any more questions, Jen, from you?
Ox na. Thank you.
Okay. So, so siguro naman the moonlighting kasama na yon yung selling stuff online. Okay, like yung mga makeup, fashion items, lingerie. Kasi people are trying to augment their income. So, yun. So, I guess that's a better perspective, no? Like, you can monitor them. At least they're talking about it in the open. So, there was another question here. Okay. So, attorney okay. So, there's a question about, I'm trying to look for the question here. Anyway, for mergers and acquisitions, okay. So what will you do to people who refuse to sign or to be part of it? Okay. Is it a redundancy or a retrenchment?
Kung if the company that they work in is going to be dissolved, that's a closure. Closure of business. So it's another ground separate from redundancy and retrenchment. Under the labor code kasi, allowed rin to terminate permanently employees if there's a total closure or partial closure of a business.
Okay. So they have to determine what happened to them.
The separation pay for closure, whether total or partial closure, is half month pay for every year of service.
Yes. Okay. So, thank you, attorney. Ang daming questions dito, but I suggest that you just go through them kasi may mga details na lang. It's also about separation pay, etc. How about Ken? Do you have a question for Attorney Paul?
Wala naman. Super informative. Wala ako sa corporate, kaya wala ako masyado.
I have a question for you, Ken. Okay, what's that look you're trying out now?
Kasi medyo may Chinese blood ako, kaya wala akong bigote. Kaya tinetesting ko lang kung ano itsura ko kung meron akong bigote. Di ba? Astig naman pala eh. Yeah.
Okay. So, Attorney Paul, okay. So, moving forward, okay. So, I think you have your Ask You Anything portion every Saturday, if I'm not mistaken. So, what should the attitude of HRs be moving forward?
Well, attitude of HR moving forward in relation.
Yeah, up to December.
Still nangangapa pa rin tayo no? Depende siguro kung ano yung company mo or yung business mo kasi iba't iba ang situation. May mga business are namamayagpag ngayong pandemic, no? In fact, they're expanding and growing, and may mga business naman na severely affected. So it depends siguro kung saang industry or saang business ka. No, but one thing is common to all is the safety and health, including the mental health aspect. No, that's a common denominator for all businesses, all companies. No, whether you are in the endangered industry or not. No, so yeah. So for me, this is an area that should be looked into. Kasi hindi lahat ng bagay, ito yung tinatawag kong may hard line approach at saka the soft approach. Kasi
So what's the soft approach from Attorney Paul?
kasi yung hard approach yan yung legalistic di ba? Disciplinary, memo, di ba? Kung ayaw mo, wag mo. Yung soft approach marami. But of course, kayo mas marunong kayo dyan because you are in the HR. So there are humane approach to certain problems like yung ayaw mag-report. Ito common question. Di ba tinanong mo sa akin kanina, ano mga common questions sa iyo, Attorney Paul, ngayong yung mga employees na ayaw mag-report dahil natatakot lumabas, takot ngang magpa-check up, di ba? Takot pumuntang hospital, takot pumuntang ayaw na, takot na sila sa COVID-19. So ayaw rin nilang mag-report for work, no? Although may trabaho, and then the employer say, compliant naman kami, 100%, compliant kami sa lahat ng protocol, di ba? Ba't ayaw mo pa mag-report? Ayaw ko lang, sir. So, yan. Common question yan, ayaw mag-report. May trabaho, ayaw mag-report. So, ano yung hard line, legalistic approach? Diyan, syempre, disciplinary. Ginawa mo ng lahat, nag-comply ka na sa lahat ng regulation, ayaw mag-report, kung nang nagbibigay ng trabaho. Di anong susunod dyan? Notice to explain, di ba? Why you should not be terminated for absences na yan, unauthorized absences na. Or even insubordination, willful disobedience na yan. Minimuan mo na So that's the hard line. Pero ano yung soft line? You have to know what's going on, the mental health of people, and of course, yung talagang, may mga tao talagang natatakot Or kung hindi man sila natatakot sila for their family. Kasi magiging carrier sila. No? So, we have to understand where the employee is coming from. Sabi naman ng employee, paano naman ako? Kailangan kung sinong magagawa, sinong tatrabaho. So ano ba ang middle grounds? Anyway, the employee who does not report for work, no pay naman yan. Kasi siya na nga ang may gusto. Ano bang problema ni employer? So, first of all, yung position ba na yun, pwede bang gawin yun ng ibang employee? Pwede ba siya mag-hire, no? Pwede naman daw. So what's preventing you from hiring? May employee ako na may trabaho dalawang employee ko kung mag-hire ako. Di ganito lang pala. Ang problema mo is gusto mo na mag-hire ng iba na hindi ka lang maka-hire ng substitute kasi may existing employee. Di find the middle ground. Tell the employee, alam mo ganito, ang problema is dahil sa employed ka pa, hindi ako makapag-hire at walang magtatrabaho ngayon. So ganito, middle ground. Kung ayaw mong pumasok, mag-file ka ng leave, prolonged leave, no? Of course, no work, no pay yan kung wala kang leave credit. 6 months leave.
Okay.
Diba? And then, since alam ko na hindi ka magre-report for 6 months, that will give me the right to hire a temporary substitute, no? A fixed term or a contractual employee na ang contract niya for 6 months only.
Okay. So, merong parang stopgap measure.
Oo, kasi yun lang naman ang problema ng employer Okay naman hindi siya mag-report. Sino tatrabaho?
Yeah. It's practical. I learned another one again. Okay. So, ito, attorney, ito yung hinahanap kong question. Okay, so daily paid sila. Okay, ang problema, so no work, no pay sila this year. Pero yung next year, parang charge na sa kanila. Parang kinakaltasan din yung holidays, yung leave credits nila for next year. Is that valid? So 2020, no work, no pay. Okay, so ang ginawa, charge yung kanilang no work, no pay at the onset sa leave credits nila. So naubos yung leave credits nila, so I suppose ang ginawa, nagsisweldo pa rin dapat sila. Kasi ang ginawa is nag-borrow sa 2021.
Oh, yes. Ganun pala. So, kung If it's advances, parang ano lang yan, dapat kasi may valid reason. Kung walang valid reason, of course, it's prohibited. But if there's a valid reason, like you can view it as a vale, di ba?
Mm-mm.
Advance. Cash advance yan eh, vale. So parang pinabali nila si employee, charge against future salaries and wages. So kung may gano'n naman pala, allowed naman yan. Pero kung ako si employer, I would document it para in case magkaroon ng problema, I have uh, the documents. At saka isa pa, one basic requirement is the written authority to deduct, no? Kasi
From
kung
the leave credits of 2021.
yes, written authority to deduct. Kasi kung salary loan or vale, humingi ka ng, di ba, may pinapapirma kang promissory note or something written authority to deduct. Dapat may ganun ka. Kasi kung hindi ka nag-document, later on, magkakaproblema ka pag naging uncooperative si employee.
So as long as may tinatanggap sila, okay, charge yun, tapos nag-borrow sa leave credits na sa 2021, valid yun. Pero kung nag-borrow sa 2021, tapos wala pa rin silang sweldo dito sa 2020, hindi valid yun.
Valid yun. That's a valid cash advance yun eh. Loan yun eh. That's a salary loan.
Hindi, wala silang tinanggap. Kung wala silang tinanggap, attorney.
What do you mean walang tinanggap?
Kasi yun yung hinahanap ko eh. I have to, the person who asked the question has to say if may tinatanggap silang cash ngayon.
So hindi clear yung question eh. No?
Oo. That's why I was looking for it. Okay. But if sumisweldo pa siya, okay, and merong evidence na nag-borrow sa 2021. Pero kung sinabi lang na kakaltasan na yung 2021 ng leave credits, tas wala pa rin tinatanggap, hindi valid yun.
Oh, that's wage deduction is, as a general rule, prohibited under the labor code. Bawal po ang wage deduction. Allowed lang yan under certain circumstances, like yung deductions for SSS, di ba? Mandatory yan. Yung mga kung taxable yung income ni employee, deductions for income tax, no? So because these are required by law. So hindi lahat, as a general rule, bawal. You have to look for an exception to the general rule before you are allowed to do a wage deduction.
Okay, I found the question, okay. Justin Bennett, hi Attorney Paul, considered as daily paid employees po kami and under labor code, no work, no pay po kami kapag special holidays. Legal po ba if ibawas na namin sa matatanggap na leave credits ng employee namin for 2021 ang lahat ng special holidays? Thank you.
Ganito po, no? Naglabas ng statement si Secretary Bello. And this was in a press conference that if we're talking about the leave credits of the employee, especially the leave credits na granted by law, like yung service incentive leave, no, yung 5 days service incentive leave with pay yan, dapat the employee must apply or must consent. Hindi pwedeng automatically i-charge ni employer sa leave credits, no? Bakit? Kasi the employee might be saving his leave credits. Baka gusto niyang mag-probinsya, no? Magbakasyon sa probinsya at iniipon niya yung leave credits niya. So you have to respect the wishes of the employee. Now, no work, no pay naman yan eh. So if the employee did not give his consent, then no work, no pay, wala siyang sweldo for those days na hindi siya nakakapasok. No, ganun lang naman yun. No, either no work, no pay, or pumayag siya na gamitin yung kanyang leave credit. But you have to ask the employee either to apply or to consent, no? Para klaro.
Actually, yun nga, ipa-follow-up question ko to kung binabayad, kung may natatanggap sila. Kasi looks like wala silang sweldo. So anyway, so that's it for tonight. There are a lot of questions here, but anyway, so Attorney Paul, where can they seek you out or message you or meet you after this FB Live from HR Shouts?
Okay. Thank you for this opportunity, to invite our participants and our viewers sa Facebook Live. We have this monthly free. Similar to this, itong ginawa natin ngayon sa HR Shouts and Whispers. I have a monthly free admission public forum, public legal forum. It's a monthly lang to, and it's every first Saturday of the month, at 10 a.m. So kailan yung susunod? November 7. November 7 at 10 a.m. It will be Facebook Live din ito, but we will share if you want to be a live participants, you can join then sa Zoom. We will do sa interested, we can give you the Zoom link, sa aming you can be part of the live Zoom participant. But kung hindi naman, you can just watch us sa Facebook Live on November 7 at 10 a.m. This is a Saturday. Ang pangalan ng program pala is Ask Attorney Paul.
Yeah. So all your questions, lista nyo and then mag-attend kayo sa November 7. Okay. So how about our moderators here, our panelists here? Anything new from you? Any projects from you? So how about Marco?
Project at the moment, Chris?
Yeah? Okay. How about Bench? Anything new from you? May pasabog ka ba?
Wala naman. Since I teach in St. Paul University, Quezon City, and I'm also its active education technology coordinator, I would like to announce on behalf of the school that we're already looking to accept enrollees for the second SEM. So marami-rami rin kasing sabihin na natin people are not really the same in terms of voting, in terms of capability or priorities sa panahong ito. We're like any other school, we're all hoping and praying na they'd be more adjusted, and kami naman, we're also more adjusted now when it comes to our capability to teach online. So for those na hindi pa nakakapag-enroll, sana makapag-enroll na. And yes, we offer Bachelor of Science, major in Bachelor of Science in Business Administration, major in Human Resource Development. So para sa mga kabataan na gustong pumasok sa Human Resource Development for the 21st century, enroll po kayo sa amin.
Okay. Before I go to Jen, Attorney Paul, may hahabol lang. Is it possible daw ba na ang monthly paid employee can be changed to a daily paid employee?
Yes. That is by agreement, by agreement of the employer and the employee. Ito yung mga kailangan nating i-submit sa Department of Labor with the employee's consent. So, allowed po yan sa magandang pag-uusap.
Basta mag-usap sila and mag-agree ang employee and then isasubmit sa DOPE. Okay. So, Jen, okay. I think I saw your post. I think you have employment posts.
Yes, our company, so we're an e-commerce company and we're setting up our Cebu operations.
Congratulations.
Yan, medyo ngarag kami. Pero, kasi right now, we're based in Metro Manila, Luzon, but we're going to Cebu, so we're setting up our warehouse there. And then soon we'll be hiring na for more positions. Right now, we're just prioritizing our HR business partner there because that person will be mainly helping us with the rest of the hiring that would happen this year. So if pwede mo mag-plug? Nagsabay na plug pala ako
Sure.
bigla.
Okay, fire away.
So if we have HR business partners who are tuning in now, or those who are HR supervisors, so we have an open HR position. We're an e-commerce company. And yon, we'll be setting up operations in Cebu. It would be located in Mandaue City. So for those who'd be interested, you can just send me a message.
Yeah,
Thank
we
you.
we posted this some announcements of this FB Live in HR Practitioners Cebu page, and also Cebu Practitioners page. So maybe there are Cebuanos who are watching right now. So get in touch with Jennifer Tan. So you can look her up on Facebook. Okay, so Attorney Paul, so we went over time. Okay, so this was an interesting session. So I hope that, people will go to November 7 on Attorney Paul's FB Live. Okay, so ask Attorney Paul anything. Okay, and then also keep on posting your comments or questions in the comment section here on the video. And then we'll see. Maybe some of our HR practitioners will answer them, or Attorney Paul will answer them. So again, okay, so this was a busy Wednesday night. So thank you for tuning in, and take care, okay? And just keep giving us feedback on topics that you want us to pursue. Okay.
Bye.
Thank you, Attorney Paul,
Thank you
Marco.
and good night.
Yes.